Hello everyone. Today I'll be talking about the amendments that could be made to a patent application or a patent specification under the Indian Patents Act. So are you aware that a patent application could be amended at any stage during prosecution and even after a patent is granted? But there are certain limitations which restrict what type of amendments you can make to a patent application or a patent specification or even the claims. So today I'll be talking about what is the manner in which you can make those amendments and what are the limitations that the Patents Act provide in respect of amendment of the patent application or the patent specification. So coming first to the provisions, Section 57 provides that a patent application or a complete specification or any document which is related to a patent application could be amended, and that request could be filed by a patent applicant or a patentee in the case of a granted patent. However, the amendments under Section 57 are subject to the limitations provided under Section 59 of the Patents Act, which provides that there would be no amendment of any patent application or a specification allowed except by way of a disclaimer or a correction or an explanation. So what all these terms mean, I'll be shortly explaining to you when I'll go through the legal position that exists in India. But for now, you can understand it as an amendment that could be made for the purpose of making any correction in the documents or the patent application or the specification, or to provide any explanation, or maybe so as to disclaim any particular portion of the originally claimed specification or the claims. Additionally, you can make amendments for incorporation of actual facts surrounding the patent application or the documents or the specification or whatever document you are amending. Then, by way of amendment, you cannot bring in any amended matter which was not in substance disclosed in the original specification. So again, when I take you through the legal position that is existing in India, this would become more clear. Moreover, if after amendment any particular claim, any amended claim goes beyond the scope of the original claims that were filed, then that sort of amendment would not be allowed under Section 59 of the Patents Act. Additionally, Section 57 subsection 1 provides that no amendment would be allowed if the amendment is sought in a patent where there is a pending suit for infringement or revocation of patent. In addition, Section 57 subsection 5 provides that by way of Section 57 you can also amend the priority date of a particular claim by providing relevant support in that respect. So you can say that okay, the priority date of this particular claim was not what I have mentioned earlier while filing the patent application. It has to be this particular date, which could be even prior to what you mentioned in the patent application. Also, while Section 57 relates to amendment requests that could be made before the controller of patents, Section 58 provides another dimension to it. Section 58 provides amendments that could be requested before a high court in case there is a revocation proceeding for a patent that is happening before the high court. And once the high court decides to amend the specification made on a request of the patentee, then the notice regarding that amendment is given to the patent office so as to correct its records. Again, amendments under Section 58 are subject to the provisions under Section 59, the limitations that we have already discussed. Coming now to the procedural requirements, the Section 57(2) read with Rule 81 provides that any application for amendment is required to be filed before the controller of patents on Form 13, and that Form 13 needs to specify the nature and reason for amendment. Procedurally, we need to provide a track change version of a document, whatever we are amending. Maybe it is a claim, maybe it is the description, or maybe it is any form of the patent application. So we identify what are the changes we are making in that, and also provide a track change version so as to enable the controller of patents to identify what are the changes that are being made. Further, Section 57 subsection 3 provides that if any amendment is being made to a patent or any document that is related to that patent, then that amendment needs to be published. Also, the Patents Act provides that in case any amendment to a patent is being made, that could be opposed by any person who is interested in that, and that opposition needs to be filed within 3 months from publication of the amendment, and that opposition needs to be filed on Form 14. This is provided under Rule 81, Sub-Rule 3B, which is read with Section 57, Subsection 4. Once an opposition is filed, the patentee has the option of filing a reply statement, which is provided under Rule 58, and the reply statement needs to be filed within 2 months of receipt of the opposition documents. If a reply statement has been filed by the patentee, then the opponent has the option of filing a reply evidence, which is restricted only to the evidence that has been filed by the patentee, and this is provided under Rule 59, and the reply evidence needs to be filed within 1 month of the receipt of the reply statement. Thereafter, the controller of patents appoints a hearing under Rule 62, and the controller takes into account whatever is the material that has been filed by both the sides and the hearing arguments that have been forwarded by both the sides, and based on that the controller gives a reasoned order deciding the amendment whether or not that should be allowed. Rule 63 provides that if the patentee wishes to withdraw his patent once an opposition has been filed, then that could be allowed, but subject to costs that need to be paid by the patentee towards the proceedings for opposition. This is all about the procedural aspects related to amendments of patent application or specification. Now what we'll see is what is the legal position that exists in India as regards the amendments and the extent to which an amendment would be allowed by the controller of patents. Under the legal position that exists for amendment of patent applications, we'll first explore the decision of the Delhi High Court in 2009 in respect of AGC Flat Glass Europe versus Anand Mahajan. This was an infringement suit in respect of a patent, and the defendant challenged the validity of that particular patent in a counterclaim. In response to the challenge on the validity, the plaintiff sought to amend its claim by narrowing down claim 1 so as to overcome the challenge, and by way of that amendment the plaintiff sought to introduce an additional element which said sensitizing material, typically tin, which was not there in the original claim or the original specification, and this was sought to be introduced in claim 1 so as to narrow it down further. And as I said, this was being done in view of a prior art that was existing and that was cited by the defendant in the validity challenge. The amendment was challenged by the defendant on the grounds that it is not allowed under Section 59. In this respect, the court analyzed the provisions of Section 57 and Section 59 and held that no new claim would be allowed which extends the scope of monopoly that was originally being sought for by the patentee. The court, however, said that narrowing down of a particular claim is always allowed because by way of narrowing down, the person is trying to disclaim a particular portion of the original monopoly that he was trying to claim. But now by way of narrowing down the claim, that particular portion is being disclaimed. And this is what is meant by disclaimer that exists in Section 59. Further, the court said to determine the scope of the original monopoly, one needs to go through the entire specification and understand what was the original monopoly that was being sought. And this was being done so as to analyze whether whatever amendment has been made would still lie within the scope of the original monopoly that was being sought or whether it goes beyond that. The court analyzed that the entire invention related to an inventive process which includes the step of sensitizing, and the amendment that was being sought, that is that of inclusion of a sensitizing material which was tin, the court observed that this amendment only clarified the scope of this particular step. So in a way, the court observed that by way of amendment, the patentee is trying to clarify the scope of this particular step, and also it is trying to disclaim because the claim is being narrowed down so as to bring in an additional limitation in the claim. Thus, the court said that by way of this amendment, no new invention is being claimed as such, and it is only lying within the scope of what was already being claimed. So, the court allowed this amendment that was being sought by the patentee. Next in line is the IPAB's decision in 2012 in respect of Spice Mobiles Limited versus Soma Sundaram Ramkumar. There was an Indian patent that claimed mobile phone with plurality of SIM cards, and there were several revocation petitions that were filed against this particular patent. One of the grounds for revocation petitions was that there were several amendments that were made during the prosecution of this particular patent and which went beyond the scope of the original claims because the number of claims were increased from 4 to 20, and thus the amendment should not have been allowed under Section 59. Moreover, it was asserted that the new matter that was added was beyond the scope of the original disclosure and the claims, as there were no details related to the circuitry that was required to accommodate the 2 or more SIMs. So all that information was later on brought into after making amendments, but it was not there within the original scope of the disclosure. To the contrary, the patentee claimed that these amendments were being made so as to clarify the matter, and these were required because the patent office raised objections regarding clarity, and that's the reason they brought in this additional matter. Again, the IPAB went into the determination of what was the original scope of the original disclosure that was filed, and found that the matter that was being added was not merely clarificatory, and there were additional features that were being introduced, and those were not a part of the originally disclosed subject matter. Consequently, the IPAB said that the effect of the added matter is that it describes something which was not disclosed in the original specification, and hence it went beyond the scope of the original specification, and thus the amendment was not allowed. So this is all about the legal position very briefly. Now I would like to summarize what we have learned. So no amendment would be allowed in case you are adding a subject matter which goes beyond the scope of the original specification. To determine what was the original scope, you need to read through all the claims and the description of the original specification and find out as to whether whatever you are adding is going beyond whatever was already disclosed. If you are adding additional features, then probably you may not be able to satisfy the requirement of lying within the scope of the original specification. Also, amendment could be made by way of disclaimer. So like you are narrowing down a particular claim, which means that you are disclaiming a particular monopoly. So that type of amendment is allowed, or else if you are adding a clarification, then probably that amendment could be allowed. Or if you are adding an explanation for a particular process or particular aspect of the innovation, then that amendment could also be allowed. So this is all about amendment of patent applications and patent specifications. If you have liked the video, please hit the like button, and please do subscribe to the channel so that you get regular updates regarding all videos that I'll be posting about the various provisions of Patents Act. Also, in case you have any questions, please drop them in the comments box and I'll be happy to take them up. Thank you very much.